Okay, should be able to share now.
I think you can see the screen.
Put it on slideshow,
I
please.
cannot- Yeah.
The very top.
Yeah. I think it's
great.
better now.
Yeah, much better. Good.
Okay. Okay then. So yeah, our group had 9 members. I don't know why I can see 8. Sorry. Let me just go back.
Yeah. Is it okay to have the video on, the presenters, when they're presenting?
I think they can.
Yeah.
Let me just. Okay. Can I start? So these group members, and I think they're in class right now. So, so this is a brief. The slides are not moving. Yeah, here we go. Okay, this is the first slide, and it contains a brief description of the Sierra Leonean conflict. So, and is a West African coastal state with a population approximated to 75% Muslims and 23% Christians. It's very famous for diamonds, gold, and bauxite production. Now, on 23rd March 1991, the internecine civil war amongst Revolutionary United Front, the RUF, led by Foday Shanko, supported by Charles Taylor, who was the pro-government civil defense forces under the leadership of Sam Norman, and the one-party military regime of All People's Congress started. This is when the civil war started on 23rd March 1991. Now, RUF, the Revolutionary United Front, seized power in 1997 and civil war intensified. Now, reports came about widespread atrocities against civilian population, especially because there was mass rape, there was abduction of women, there was forced recruitment of children, summary executions, among other conflicts and that were happening in that time. So generally, this war started on 23rd May 1991. That is when it intensified, actually. So I think this is a brief description. Now we can move to the next slide. Yeah. Now this is the process of its creation. I don't know if Cosmas will be able to present. Cosmas?
I'm not sure if he's in the class. You can just continue. to the.
Okay, very well then. Now, so in the Long Peace Agreement, the Sierra Leone government and RUF, the United Nations signed as a witness with an explicit reservation stating that the United Nations does not accept immunity for war crimes and crimes against humanity. Now, the government of Sierra Leone requested the United Nations to establish a tribunal to prosecute the perpetrators responsible for violations of international humanitarian law, and an agreement was signed between United Nations and the government of Sierra Leone in 2000. Now, this is when the special court was established in 2000 after the between United Nations established a tribunal which was to prosecute the violations of international law. Now, on 14 August 2000, the United Nations putting the process to establish this tribunal. Yeah, this is now when on 14th August, that is when the special for Sierra Leone was established. This was established. This oh, sorry, my network is kind of. We can just continue. I'm sorry for that. Yeah, special court was established, and it began its work in 2002 after the agreement between the United Nations and
Recording in progress.
The court's jurisdiction United Nations and the decision of the court. Now we move to the structure, which is on
it
your
just me?
screen.
I can barely hear you, Flora, so I don't know whether it's my network or it's on your side. I can barely hear you.
Well, I can as well not hear completely. I guess if another group member can help Flora, we would join as a class.
Yeah, please, is there someone else who can be able to assist Flora from the group? Because I can barely hear what she's saying.
Sorry, am I audible right now?
Well, but you keep breaking up a lot. I can
Okay.
not hear what you're saying.
Okay, I think maybe I can just present on the structure and then I leave the other members to continue. How about that?
Yeah, I thought someone else could assist you at this stage, actually. You've done a lot.
Okay. Okay, let me just tell. Okay.
Group 5 members, come on. Someone to assist.
I can assist her.
Please.
Okay, that's okay. That's fine. So
Okay. Yeah, so the structure of the Sierra Leone Special Court and its composition, 2 trial chambers with 3 judges each. Sierra Leone had to appoint 1 judge out of the 3 judges in each of the trial chambers. 1 appeal chamber with 5 judges. Sierra Leone had a duty to appoint 2 judges out of the total 5 in the appeal chamber. Sierra Leone also had a duty to appoint deputy prosecutor and UN will fill the other vacancies of the lead prosecutor and registrar. The special court represents the first hybrid approach to international criminal justice and is proven example that hybrid model of national ownership complemented by to be funded by voluntary contribution. Next slide, please. Flora, can you hear me?
Yeah, I can hear you.
Next slide, please.
Okay.
Yeah. So thank you. So the rationale for creating the Special Court of Sierra Leone, 1, accountability and justice. The Special Court was established to ensure that accountability for the widespread atrocity committed during the Sierra Leone Civil War was, brought into justice. Then the second one was in relation to international humanitarian law and human rights, and this is in line with the principle of international humanitarian law and human rights, and which seek to end the culture of impunity associated with such conflicts. The third rationale why the court was created was prosecution of the perpetrators. So this was the aim to prosecute the individual, including the Revolutionary United Front's rebels and other actors who are responsible for the crime. And then the fourth reason was addressing egregious violation, and the special court was to respond to the egregious violation, and this reflects the commitment from the international community to address this crime through legal means. And then the fifth one, which is the final rationale why the court was created, was restoration of justice. The restoration of justice, and this was to ensure that the victims of the family get the justice, and the court was now to prosecute the individual who commit this crime. So I hand it over to my colleague Roy, who will be taking us through this part.
Yes, good evening, everyone. I hope everyone can hear me. I will be taking you through the jurisdiction and powers of the Special Court for Sierra Leone. The Special Court for Sierra Leone had a well-defined jurisdiction and powers tailored to address specific crimes during the Civil War. Its authority encompassed prosecuting individuals for war crimes, crimes against humanity, and serious violations of international law, covering the period between November 30th, 96 to the signing of the Lomé Peace Agreement on July 7th, 99. The tribunal's jurisdiction applied to individuals within and outside Sierra Leone, showcasing an extraterritorial reach for international justice. This broad scope enabled the court to pursue accountability for crimes, regardless of the location of the perpetrators. The court's powers included issuing arrest warrants, conducting investigations, and holding fair and transparent trials. And these powers were enshrined in Article 1 to 8 of the statute for the Special Court for Sierra Leone. The powers are as follows. I'm sure they're not on the slide, so I'll just briefly run through a summary of the articles. If you wish to access the articles in verbatim, I'm sure Google is your friend. So Article 1 establishes the Special Court for Sierra Leone to prosecute individuals responsible for serious violations of international humanitarian law and Sierra Leonean law committed within the territory of Sierra Leone. Are we okay up to there? Or am I going too fast? Can everyone hear me?
Yes,
Yeah,
I can hear you. Okay.
Okay, let me proceed to Article 2. If you're taking notes, feel free to stop me whenever you feel like I've said something important. So Article 2 defines crimes falling under the jurisdiction of the court, including war crimes, crimes against humanity, and other offenses as defined in the statute. Article 3 specifies the temporal jurisdiction of the court covering the period from November 30th, 96 to the date of the signing of the Lomé Peace Agreement in Sierra Leone on July 7th, 99. Article 4 details the personal jurisdiction of the court, addressing who can be held criminally responsible, including individuals who planned, instigated, ordered, committed, or aided and abetted in the planning, prepping, or execution of crimes. Article 5 outlines the constitution and jurisdiction of the chambers of the court, which include trial and appeals chambers. Article 6 covers the composition and appointment of judges for the court, ensuring a mix of international and Sierra Leonean judges. Article 7 addresses the independence and the impartiality of the judges, emphasizing the need for their integrity and the importance of the court's independence. Article 8 establishes the office of the prosecutor for the court, defining the prosecutor's functions, powers, and independence in initiating investigations and prosecutions. I think its unique composition of both international and Sierra Leonean judges reflected a collaborative approach to justice, seeking to balance the interests of the international community and the affected state. This blend of elements aimed to ensure a comprehensive and impartial pursuit of accountability for the atrocities committed during the conflict. The court played a crucial role in addressing heinous crimes committed during the Civil War. One notable case exemplifying its jurisdiction and powers is the trial of Charles Taylor, the former president of Liberia. Taylor was indicted on charges related to his support for rebel groups in Sierra Leone, contributing to widespread atrocities. Next slide, please. Flora. Okay, the court's jurisdiction extending beyond Sierra Leone's borders allowed the court to prosecute Taylor despite his status as a foreign leader. This case underscored the tribunal's commitment to holding individuals accountable for crimes committed in the region, emphasizing the importance of extraterritorial reach in addressing complex conflicts. In terms of powers, the court's authority to issue arrest warrants and conduct investigations was pivotal in bringing Taylor to trial. The process demonstrated the court's capacity to navigate international complexities and enforce justice against high-profile figures implicated in serious international crimes. Another notable case is the trial of the members of the Revolutionary United Front, in parentheses RUF, such as Foday Sankoh, Issa Sesay, which illustrates the court's commitment to transparency and fair trials. The court's ability to hold accountable those directly responsible for war crimes and crimes against humanity highlighted its dedication to justice and reconciliation in Sierra Leone. The collaborative approach with a mix of international and Sierra Leonean judges was evident in the court's composition. This collaborative model sought to balance global perspectives with local insights, ensuring comprehensive understanding of the conflict and promoting a sense of ownership over the justice process within Sierra Leone. Another significant aspect of the court's jurisdiction and powers lies in its establishment as a hybrid tribunal, which incorporated elements of both international and domestic legal systems, fostering a collaborative approach to justice. The court's creation was a response to the challenges of balancing the need for international accountability with respect for Sierra Leone's sovereignty. The case of the prosecutor versus Norman Kondewa and Fofana, involving the leaders of the civil defense forces, parentheses CDF, illustrates the court's application of international standards within the context of the country's legal framework. The trial showcased the blending of international legal principles with Sierra Leonean law, promoting a harmonious and inclusive approach to justice. The court's power to conduct outreach programs and engage with local communities contributed to its broader impact. These efforts aim to enhance understanding of the judicial process, address the needs of victims, and promote reconciliation. The case of the prosecutor versus Sesai Kalon Angbao, involving leaders of the Armed Forces Council, parentheses, AFRC, demonstrated the court's commitment to involving affected communities in the pursuit of justice. The court's jurisdictional timeframe from November 30th, 96 to the signing of the Lomé Peace Agreement in 99 was strategically chosen to encompass critical periods of the conflict. This allowed the court to address the root causes of the conflict and provide a comprehensive account of the atrocities committed during that time frame. Are we okay up to there? Ama kuna mahali mmepotea? Hello, guys. Is anyone in class? Is everyone in class?
Yes. Yeah, good.
Okay. So in conclusion, the court for Sierra Leone's hybrid structure illustrated by cases like the prosecutor versus Norman, Kondewa, and Fofana, coupled with its outreach initiative and strategic jurisdictional focus, further highlight its commitment to a holistic and collaborative approach to justice in post-conflict settings. So I think with that, I've exhausted the jurisdiction and powers. So I'd like to hand over to my colleague who will take you through the next part. Thank you.
Good evening. I'll be taking you through the success of the Special Court of Sierra Leone. So the Special Court achieved many successes. One of the notable successes is the prosecution of Charles Taylor, the former president of Liberia. This was a landmark case that demonstrated the court's ability to hold even the most powerful accountable for their actions. Next slide. So the Special Court played a crucial role in advancing jurisprudence of international criminal law. Through its judgment, the court clarified legal concepts and set important precedents, contributing to the evolution of the field. The Taylor trial, for example, addressed the question of whether a sitting head of state could be held criminally responsible, establishing an important precedent for holding leaders accountable for their international crimes. Next slide. So I go to the failures. However, the court faced many challenges and shortcomings. So the issue of witness intimidation and protection was a persistent problem, hindering the court's ability to secure testimony from key witnesses. And then the length and the cost of the trial also raised concern about the efficiency of the tribunal. Balancing the demands of justice with the practical constraints of conducting trials in a timely and cost-effective manner proved to be a complex task. Next slide. Then finally, the inclusion of recruitment of child soldiers in the list was challenged as a breach of principle of legality, but the court determined that this was a war crime under customary international law before November 1996. A very controversial issue was what to do with many child soldiers who had committed serious crimes during the Civil War. The solution finally chosen was to exclude jurisdiction over children under the age of 15 at the time of the crime and to include special provisions about treatment before and after conviction of juvenile offenders between the ages of 15 and 18 years. So that marks the end of success and failures. I'll hand over to the next presenter.
Yeah, so the Special Court of Sierra Leone made several contributions to the international criminal law. To start with, they were able to prosecute head of states and corporate actors, meaning state heads were liable for individual criminal responsibilities. An example, as we have seen, is the trial of Charles Taylor while he was a sitting-in president. Special Court of Sierra Leone also pioneered hybrid courts. This was combining international and national elements that gave platform to address complexities of post-conflict of justice. There was also the expansion of the scope of international law. The jurisprudence of the Special Court of Sierra Leone contributed to the development of precedents and legal interpretations in areas such as sexual violence, which was classified as a crime against humanity. Reconciliation and legacy. Sierra Leone were educated on international criminal law and need for accountability. The court also is known to have left a legal and the child soldiers as enslavement.
I think
We're losing you, Mudoni. You can't hear.
Yeah, that was the end of the contributions that Sierra Leone, Special Courts of Sierra Leone made to international criminal law.
yes, that was all we had from group 5. I now welcome the questions session. Hello guys, can you get me?
Hey, you can get you. Flora.
Okay, maybe any concerning question? Yeah, I welcome all.
Okay, before I raise my concerns, although your entire group has just been reading, you people are just coming to read slides for us, Buena. That's not very fair. Anyway, let's hear questions. Solomon, you wanted to say something?
Yes, I was interested to hear how the trial, the indictment and trial of Charles Taylor turned out, because I still see him in the media giving interviews. I don't know whether he was acquitted. I would want to hear from the group.
Promoting reconciliation.
Okay, I think I heard that. Alfred?
Yes, Mwalimu, I picked out the issue of the temporal jurisdiction, in this case from 1996 to 1999. And then here, at least, we are given a hint that it was strategically put at that place to encourage.
Hello, what's happening? I lost Alfred also. Is it my... Hello?
I think we
Can you hear Alfred?
From my end, I can't hear him unless the other class members can hear him.
No, neither can I. So we've lost Alfred. But hey, you people, prosecution of Charles Taylor, Buena. How can you write Taylor like that, Buena? That's very wrong for a title. Yeah. Aya. Questions? Jurisdiction.
Sorry, sir. With regards to the question on the prosecution of Charles Taylor, on 26th of April 2012, the trial chambers found Charles Taylor guilty on 11 counts on the modes of liability, of planning of crimes, and for aiding and abetting crimes committed by the rebel forces of Sierra Leone. On 30th May 2012, the former Liberian president, was given a single sentence of 50 years in prison, and they appealed. the conviction and the 50-year sentence. So, yeah.
And what happened to the appeal?
The status of the appeal.
The status of the appeal is what we're trying to follow on right now. At this moment, I don't have any information on the status of the appeal, but just give me like 5 minutes and I'll get back to you on the same.
Okay. Meanwhile, as you're looking for that, I think the other question that I'd like to hear from you, from this particular group, is what is the impact? You talked about a hybrid court. Okay, I'd like you to break it down a little bit more. When you say a hybrid court, what does that mean? So that the rest of the class is with you. And then secondly, what is the difference between this particular hybrid court and other courts, and what advantages does it bring or disadvantages does it bring? Thirdly, I have my question in relation to, you said Sierra Leone is the first country that had a court that was based where the offenses took place from the Nuremberg. And so the question is, what advantages and disadvantages did it have? My other question is on jurisdiction. Remember what I said about jurisdiction? I'd like it to be broken down a little bit more in terms of time, in terms of the offenses, in terms of what is the timeline that the court has, and how did they reach on that? How did they come up with that timeline? Okay, and then I think let's leave it at that first.
Okay, in regards to the, sorry. Would you like to proceed or should I start?
You can go ahead.
Okay, so in regards to hybrid courts and tribunals, these are basically institutions that are created to address particular situations for a limited amount of time, but their nature incorporates international and national features. These courts and tribunals are composed of international and local staff, and they apply a mix of international and national substantive and procedural law. So this unique structure incorporates elements of both international and domestic legal systems, fostering a collaborative approach to justice. And this is as a response to the challenges of balancing the need for international accountability with respect for the nation's sovereignty, the nation in question. For example, Sierra Leone has one, Cambodia has one, which other country has one? And a number of other countries. Lebanon has one too. So the hybrid system is to illustrate the application of international standards within the context of a country's legal framework, basically. Yeah, that's all I have in regards to the hybrid tribe.
What advantages does it offer compared to the other ones? Hey, is this group there? Surely, I'm even wondering.
Sorry. I think that was an issue with my mic. So, unlike purely international courts, hybrid courts are said to enjoy greater legitimacy since they rely heavily on local staff, and they particularly lay their seat in countries where, for example, the atrocities or the crimes occurred, and they apply a blend, as I had mentioned earlier, of international domestic law and set out legacy building mechanisms.
Okay, just to add on the advantages of hybrid tribunal. Now, the benefits of hybrid tribunal are, now, the crime is not distant from where it occurred, and of course, justice remains within the jurisdiction of the state. In addition, the decisions are more likely to be respected and upheld if they are made within a country.
Laura, please pardon.
Okay, what I'm saying is the benefits of hybrid tribunal are vast. There are very many, most specifically for the rights of victims. Now, the crime is not distanced from where it occurred, and justice remains within the jurisdiction of the state. In addition, the decisions are more likely to be respected and upheld if they are made within a country. Did you get?
Are you people done?
Yes, we understand. And perhaps I would ask that, given you have said that the decisions are a bit more legitimate, is that an indictment on the ICJ, which currently has a
Moses,
permanent seat?
I saw someone who had a hand up.
It's my hand, Mwalimu, but a colleague of mine is asking a question. I think it's
Who is
Kangogo.
asking? Who is speaking? Sorry.
This is Moses, but you just mentioned my name while someone else was speaking. So I don't know whether to go ahead or to let him finish.
I don't know who was speaking. Kindly, please repeat yourself because I didn't hear the question.
No, I was asking Mwalimu.
Yes.
That given they have outlined one of the advantages being legitimacy of the decisions that will be given by the court, is that an indictment on the ICC, which has a permanent seat at The Hague?
Okay. Okay, good. Thanks, Koech, for that. Moses, you also had a question?
Mine is just out of curiosity. This hybrid approach seems to have worked in Sierra Leone. I'm just wondering, you remember in 2007 when we had some issues in Kenya, then, the international community, or the ICC, tried giving us a chance, and there was the famous say, don't be vague, go to Hague. I'm just wondering if the group somehow were able to find the reasons why the hybrid system seems to have worked in Sierra Leone. And apart from that, was there an opportunity given to Sierra Leone to, try to manage this with the municipal laws? Because I remember when we had the team from Rwanda, when we were talking about the genocide the other time, we were able to see, how some other victims were able to be handled by the system in Rwanda. So, just out of curiosity, if the group can shed more light on that.
Okay, thanks. And also important, in relation to the Taylor trial, Taylor was at this time, when he's actually on trial, was supposedly participating as a peace person in the peace process in Liberia. So there's a peace process, and Taylor was supposedly one of the people who were involved. Yet at the same time, he was supposed to have been indicted as a war criminal. And so where does the balance, how did the court end up with the balance that, no, this guy is a criminal rather than a peace, a proponent of peace? Then the last question will be in relation to the establishment. I talked about jurisdiction. You guys, people have not talked about jurisdiction, but more importantly, also in relation to the establishment of this court, seems to be an agreement between the Sierra Leone government vis-a-vis and the United Nations. Whereas the other tribunals that we looked at were established under this by the Security Council. So what advantages or disadvantages arise out of such an establishment where this is just an agreement rather than the Security Council being involved in its creation? To the team, I hope you noted all those questions. Hi, this team, I'm in life, Bwana. Muturi Cosmos, are you part of this team?
Yes, Mwalimu.
Yeah.
So now, on the creation of this code, just like Mwalimu asked, how Charles Taylor was indicted, having participated in a peace agreement. In fact, the peace agreement was a long peace agreement. And because these people knew they had played a role in the war, one of the things that they were for was an amnesty, or that the people that had participated in the war that would have been indicted, that they wanted to defend the trials or to defend prosecution or accountability. But we found that later in when this court started operating, it ruled out amnesty. So, and it is, if you find that even when the UN participated in that peace agreement signing, it was honored as a witness, and they were very categorical that amnesty will not be availed to all those people that had gotten involved in the war. So now, on the speciality of the court, or how it is a special tribunal, is that it involved the members that were from Sierra Leone. That, for example, in the trial chambers, the two trial chambers that were comprised of 3 judges, one of the judges to come from Sierra Leone. Then on the appeal chamber that comprised of 5 judges, 2 judges could come from Sierra Leone. So the others could be appointed by the UN. So that's how it is, a special court. It's like an internationalized tribunal. So on the questions of jurisdiction, one is that among the powers of the court is that it was to try even those people that had violated Sierra Leonean laws, the people that had violated international humanitarian law, but then that was given a timeline that was between the 10 years, because they say for the 10-year period between 1981 and 2001 when the court was formed. So although we know that this war in Sierra Leone had been there for many years, but the court could not have opened that window too wide, so they limited it to a period. That is when the court could have jurisdiction.
My host is not speaking.
I cannot hear you. Anyone in this group, please. Okay, I think this group. Okay, let's move on. I think you people you've not done justice to this particular proceedings. I think there's a lot more that you could have covered and in a better way. Anyway, let's move on to the next one. Extraordinary chambers for Cambodia. Cambodia.
That sounds like our group we were to present today.
Who was to present today, apart from you?
Okay. Let me retreat back to our group and just find out.
I hope we'll do a good presentation. Don't just come and read notes. Cambodia team, let's do it. Let's do it.
Well, if you give us just 2 minutes, I can see we are talking in our house. Someone is saying there's a Lebanon group before us because ideally we are not reading Mwalimu, I think.
Did they say there's a Lebanon camp before you?
Yes.
Okay, it doesn't matter. Lebanon, are you ready?
Yes, sir, we are ready. Kindly grant me sharing, right?
I think you should have sharing rights.
Yes, now I do. Just give me a second.
Okay.
Kindly confirm whether you can all see our screen.
Yeah, we can. Yes. Put it on slideshow, please. Order.
Right, I believe we are good to go. Just a minute, let me switch on my video. I don't know because I can't seem to see it. Okay, I'll just proceed and then I'll figure it out when my time comes to present. So this is group 6, and we were covering the Special Tribunal for Lebanon. And our group was comprised of 6 members, myself, Solomon, Patrick, Wilson, Washington, and Maureen. And I can confirm that each and every member participated in the group work, in that everyone was able to do that which they were supposed to do, and they did it well. So we will just proceed to do our presentation. But then before then, I would... All right. So we'll basically start off with the process of creation of the tribunal, and then we'll go ahead and do the rationale for creation of the tribunal. And then we will also cover the jurisdiction and powers of the tribunal, the success and failures of the tribunal, and then we will finish off by doing the major contributions of the tribunal to international criminal law. And at this particular juncture, I will pass on the baton to my teammate to take it on from here.
Thank you, Chelsea. This is Solomon. I'll handle the process of creation of the tribunal. And I'll do this jointly with my colleague who we did this part with. The Lebanese government was caught up in a crisis after the internal havoc that led to the killing of their prime minister, Rafik Hariri, in 2005. And around this time, there was strong suspicion that internal strife between Rafik Hariri and the President Bashar al-Assad had led to the killing of Rafik Hariri with the involvement of the government of Syria. That's why it was not possible to institute internal adjudication and trial of the people who ordered the hit. And the Lebanese government approached the United Nations because naturally how governments are formed is that the stakeholders at the high level of government have their own ethnic support, and that if it was left unattended would have led to breakdown of civil order. So it had to be addressed, and the Lebanese government approached the United Nations, and they signed an agreement for the special tribunal for Lebanon to be established. This was around January of 2007 and February 2007. And the agreement was subsequently ratified by the Lebanese parliament. However, the speaker did not immediately convene the parliament to vote on it. It took time. So later on, the UN Security Council did a resolution and reaffirmed its commitment to have the perpetrators of the murder of Rafik Hariri tried. And the tribunal started operations in 2009. On March 2006, there are key dates involved. The UN Security Council responded to Lebanon's request through Resolution 1644 of 2005 on December 2005, with the Security Council reaffirming its condemnation of the February 2005 attack and requesting the Secretary General then to help Lebanese government identify the assistance needed to try those who were eventually charged with the perpetration of the attack. Another key date is March 2006, in the process of creating the tribunal, where through the Security Council Resolution 1664 of 2006, the Security Council requested the United Nations Secretary General to consult with the Lebanese government on the establishment of an international tribunal to try those responsible for the February 2005 attack. The UN Secretary General submitted his report on the deliberation between the UN and the Lebanese government on the establishment of a special tribunal to the Security Council in November 2006. And later on, the President of the Security Council responded to the Secretary General's request on the November 2006, requesting that the decision to form a tribunal proceed in conformity with the Constitution of Lebanon, with final steps for the conclusion of the agreement for the establishment of a special tribunal. Would you kindly move to the next slide? The Lebanese government and the United Nations signed an agreement for the special tribunal for Lebanon on the 23rd January 2007. And as I had earlier on alluded, it was sent to the Parliament of Lebanon for ratification. On April 2007, majority of the members of Lebanese Parliament sent a memorandum to the UN Secretary General calling for the Security Council resolution under Chapter 7 of the United Nations Charter to establish a special tribunal. And this was done on May 2007, where the Lebanese Prime Minister then requested the UN Secretary General to put the issue of the special tribunal for Lebanon before the Security Council as a matter of urgency. The United Nations Security Council authorized the establishment of the special tribunal for Lebanon on 30th May 2007. adopting Resolution 1757 of 2007 under Chapter 7 of the United Nations Charter. And the resolution stated the provisions of the agreement between Lebanon and the United Nations would come into force on the 10th June 2007 unless Lebanon notified the United Nations that legal requirement for its entry into force had been complied with before then. The provisions then after of the agreement came into force on 10 June 2007. And in August 2007, the UN Secretary General announced that the Netherlands had agreed to play host for the tribunal. The tribunal officially began its operations in March of 2007 with the swearing in of the judges and the commencement of the investigation. I think with that, I'll hand it over to the next presenter, but we'll be happy to circle back when we have questions and answer session after the presentation. Thank you, Chelsea. We could hand over to the next presenter.
Thank you very much. My name is Wilson Wesonga. I was handling the rationale for creating the tribunal. So, following a series of killings and bombings in Lebanon, the assassination of the former Prime Minister Rafik Hariri on the 14th of February in a large explosion that killed 21 and injured 226 people near the St. George Hotel in downtown Beirut. On the 13th of December 2005, the Lebanese government requested that the UN create a tribunal of an international character to try all those responsible for the 14th February attack and to expand the mandate of the UN Independent Investigation Commission to investigate assassinations, assassination attempts, and explosions from 1st October. So to shed a little light on this, the year before Rafik Hariri's assassination, he had been embroiled in a row of over the extension of the pro-Syria presidential term, President Lahoud. He was opposed to the amendment, but he signed the document under pressure. So, under the Syrian in the constitution, the amendment was to allow a 3-year extension, and Hariri was not for it. So, in September 2004, a UN Security Council resolution had put pressure on Syria over its role in Lebanon, and it called for free and fair presidential elections, and the withdrawal of foreign forces, and for the disbandment of armed groups in the country, which included the pro-Damascus Hezbollah. So in October, Hariri had quit as prime minister, and the turmoil in Lebanon was set against a backdrop of upheaval in the region, where the power balance had been turned on its head by the then US-led invasion in Iraq. So this had set a stage for an escalation of rivalry between the Shiites of Iran and its allies on one hand, and which included Syria, and the US-allied Sunnis, who are the Gulf Arab Emirates. So Rafik Hariri's assassination had ignited the Cedar Revolution and mass protests against the Syrian presence in Lebanon under growing international pressure, and Syria eventually withdrew its troops from Lebanon. The Lebanon political landscape was reshaped by this move. So following these events, Hariri's son, Saad Hariri, had led a coalition of anti-Syrian parties who were known as the March 14, which was backed by Western states and Saudi Arabia. So the Syrian Lebanese allies, including the Shiites, Hezbollah, gathered into a rival alliance called March 8th. A sectarian divide emerged between the Sunnis and the Shiites. So Lebanon's now these events kept unfolding, and the Lebanese two main Christian leaders, Michel Aoun and Samir is it Geagay or Geagea, returned back into politics, and whereby Aoun was in exile and Geagea was released from jail. With that, I would like to hand it over to our next presenter. Thank you.
Maureen, kindly proceed to present.
Good evening. Am I audible?
Yes, you are.
So I'll be taking you through the jurisdiction of the Special Tribunal of Lebanon. And the first one is the particular, specific, or personal jurisdiction. And this jurisdiction refers to the power that a tribunal has to make a decision regarding the party being sued in a case. It involves the tribunal's ability to hear a case and make judgments or rulings regarding that party's criminal liability. Article 1 of the Statute of the Special Tribunal for Lebanon provides that the tribunal has jurisdiction over persons responsible over the attack on February 14th, 2005, resulting in the death of former Lebanese Prime Minister Rafik Hariri and injured or killed other persons. And the second type of jurisdiction is the special temporal jurisdiction. And in this case, there's the limitation when it comes to time and also in terms of scope. And it refers to the authority or power of a court to hear and adjudicate cases based on events that occurred during a specific period of time. Special temporal jurisdiction is often invoked in the establishment of the international criminal tribunals or courts that are created to address specific conflicts or incidents. These tribunals are granted the authority to prosecute individuals for crimes committed within a defined time frame, typically associated with a particular conflict or historical event. And this particular jurisdiction is important in that it is an extension of the particular or specific and the personal jurisdiction, because between 1st October 2004 and 12th December 2005, it has been proven to have been connected to the events of 14th February. And the mandate also grants the tribunal jurisdiction over crimes committed at any later time that are related to the attack on February 14th, 2005, as determined by the parties and approved by the UN Security Council. And the office of the prosecutor must provide prima facie evidence of a link, such as criminal intent, the reason for the assaults, the kind of victims targeted, the patterns of the attack, and the perpetrators involved, in order to request jurisdiction over these cases. Next slide. The third jurisdiction is the
We lost you, Maureen. I can't hear anything. Come on, take over.
Let me take over, sir. So when it comes to the concurrent jurisdiction, which is the other kind of jurisdiction that the Special Tribunal for Lebanon has, it basically touches on the fact that the Special Tribunal for Lebanon and the National Courts of Lebanon having more or less the same legal competence to entertain the same case. And that is what concurrent jurisdiction is all about. And reference is made to Article 4.1 of the Statute of the Special Tribunal for Lebanon. And here we are seeing a scenario where the Special Tribunal for Lebanon and the national courts having having similar legal competence when it comes to entertaining the same case. But then the difference comes in whereby now we have the tribunal having some sort of preeminency, having some sort of greater importance over the national courts of Lebanon. And moving forward, in other international tribunals, when you are making reference to concurrent jurisdiction and primacy, these two particular terms have been interpreted and applied to mean that the international tribunals sit at the top of a vertical jurisdictional hierarchy. And this is similar with the case of now the Special Tribunal for Lebanon, as well as the national courts that are in Lebanon. And when it comes to now the concurrent jurisdictional relationship that is present between this national courts of Lebanon, as well as the Special Tribunal for Lebanon, is the fact that when it comes to the Hariri incident, at least, the Special Tribunal for Lebanon has been created with a view to replace the jurisdictional competence of the Lebanese judicial authorities, and which is why Article 4.1 of the statute states that this particular tribunal has some sort of precedence over the national courts of Lebanon. And this is on the issue of concurrent jurisdiction. So I will hand it over to the next person to take us through the next bit of the presentation. Seeing that the same person has just dropped, I will proceed and do the powers of the tribunal as well. And we decided to sort of give it a mini split so as to ensure that we are able to effectively and in detail tackle these two distinct yet close sections when it comes to this particular presentation. And the first power that the Special Tribunal for Lebanon has is the power to hold trials for the people that were accused for carrying out the very popular attack of 14th February 2005. And this is the attack that involved the assassination of the former Prime Minister of Lebanon, bin Rafik Hariri, alongside 22 other people who were killed. And aside from these 22 other people, there were 225 others that were injured as a result of this particular attack. And the other power is that this particular tribunal has the power to apply the provisions of the Lebanese criminal code relating to the prosecution and punishment of acts of terrorism, crimes, and offenses against life and personal integrity, as well as illicit associations and failure to report crimes and offenses, including the rules regarding the material elements of a crime, criminal participation, and conspiracy. And this particular power can be found in Article 2A of the Statute of the Special Tribunal for Lebanon. And here we are seeing an application of the domestic laws of Lebanon in play when it comes to now the prosecution, when it comes to the punishment of the acts of terrorism, crimes, and offenses against life, etc. Another power of this particular tribunal, which is found under Article 22 of the Statute of the Special Tribunal for Lebanon, is the fact that the Special Tribunal for Lebanon has the power to conduct trial proceedings in the absence of the accused. And this only happens in the case whereby the accused in question has expressly and in writing waived his or her right to be present, has not been handed over to the tribunal by the state authorities concerned, and the accused now in this particular context has absconded or otherwise cannot be found, and all reasonable steps have been taken to secure his or her appearance before the tribunal and to inform him or her of the charges confirmed by the pretrial judge. And this is actually a very, very unique kind of power and a very, very unique feature of the special tribunal of Lebanon, because we are seeing a scenario whereby a trial in absentia is taking place. And in this particular instance, it means that the accused is not present and the accused is not in custody of the tribunal. And this has not happened in other contemporary international courts. And we are even seeing a scenario whereby now the statute is even going ahead to give the scenarios, to give the conditions, to give the situations in which trials in absentia are possible. And just as I wind down on this particular presentation, I would also like to state that when it comes to now the aspect of the trial in absentia in regards to the power of the STL to actually, have this trial in absentia of the accused, it's important to note that if the accused does not appoint a counsel, then now a counsel will be assigned by the defense office. And we are seeing a deeper interpretation and a deeper application of this particular power of the tribunal. I will now hand it over to Washington to take us through the successes and failures of the Special Tribunal of Lebanon.
Good afternoon, classmates. I will be taking you through success and failures of the STL Tribunal. First of all, I'd like to say that the Special Tribunal for Lebanon has been a complex and a controversial institution since its inception. Assessing its success and failures requires a nuanced understanding of its achievements and shortcomings. And it is, as it has been well put by my colleagues, you could trace through why they needed this. I'd also like to bring to your attention before I start mentioning these successes and failures and explaining them, that the STL was created by the United Nations Security Council in 2007 at the request, I want you to underline the word request, of Lebanese government. And the reason why you have to underline the word request, it will bring us down and remind you when you're discussing about the challenges and failures of this tribunal. These things such as the political affiliations, the limited enforcement powers, the lengthy legal processes, and the public skepticism all were covered into the legal aspect of the Lebanese legal regime trying these offenses, and they decided that it was only the United Nations Security Council that could assist them in bringing something that they could see to be fair to both sides of the void. Now, one of the successes of the STL was the indictment and the verdicts that came out of it. Special tribunals for Lebanon, first of all, is located in the Hague, Netherlands, and has conducted a fair and impartial trials in accordance with the international standards of justice. Hezbollah, which is and was a political party affiliated in Lebanon, had a strength of political will in that time and had a following in that time. That withstanding, the STL successfully issued indictments against several individuals associated with the Hezbollah in connection to the assassination of Rafik Hariri, the Prime Minister of Lebanon, and it also rendered verdicts against some of the accused, and these were the trials in absentia, since individuals were not apprehended. We also see the second success as the legal precedents. One, I'd like to bring to your attention that Lebanon is in the Middle East, and in the Middle East, by nature and default, they build untrustworthiness with the Europeans on the other side. They feel, even without engaging, that those people don't come with clean hands when they want to offer them equity. So most of the time, they look at them as if they are not going to get justice. So Lebanon opened a very big door to the Middle East for international trials against crimes. The legal precedents was set for international criminal justice in the Middle East by the hybrid tribunal, combining the elements of both international and Lebanese laws. It established and demonstrated the international community's commitment to holding individuals accountable for the acts of terrorism and political assassinations. Now, the delivery of justice of the STL was successful because of the investigations that were done and the prosecuted individuals that were accused. However, it was felt by the common wananchi that in Lebanon that this was not enough. However, as much as it was felt like that, a bigger number, that is what is called democratic number, thought that it was a success through this. The third one was international corporations. International corporations, that the tribunals fostered international corporations and collaborations in addressing transnational crimes. Its establishment showed the commitment of the United Nations and the international community to pursue justice for graver offenses. Going to the challenges which developed into what is called failures. If someone could scroll to the failures. Yes, yes, there, the first one, yes. The first obstacle that was seen, that I mentioned before, was the obstacle of political obstacle. The politicians, I want to say that Hezbollah, in repetitiveness, so that it brings an understanding to us, that Hezbollah was one of the political parties, and it was the one that was sought to be an arm that was used to kill the prime minister. The STL faced political interference from both the Lebanese and the Syrian authorities. The STL faced significant political challenges, both domestic with Lebanon and internationally. The political situation in Lebanon is a complex one, and the tribunals became entangled in regional and internal political dynamics, impacting its effectiveness. The tribunal faced challenges, including political and logistic obstacles, and it took several years for the trials to proceed. The trials were conducted in absentia, in absentia, and the accused individuals were not apprehended. I'd like to say that the reason why there was this long time before these trials began. When the trial was set up in 2007, it did not start immediately. There's a long time that was taken for this trial to begin. there are several reasons why the special tribunals for Lebanon that was very unique and a unique legal framework took time to start off. And the reason is because of the personal jurisdictions that were there, and the concurrent jurisdictions that we had seen before, and also we had seen that the legal and procedural issues that were entangling between these new, what they could have seen as a new justice system that was being established. You know, establishing a new international court involved complex legal and procedural challenges. The STL had to develop its own rules of procedure and evidence, which required extensive consultation and negotiations with international legal experts, recruiting qualified judges, which these judges also could not be detested with either of the parties, either the Hezbollah part or the other parties, and staff from different countries also took time and the efforts. The STL needed to secure fundings from the international communities too, which involved complex diplomatic negotiations. So Lebanon government needed to pass domestic legislations to cooperate the STL and implement its decision. Otherwise, these decisions were not going to be very, they could not hold a lot of water if Lebanon government did not pass these domestic legislations to cooperate the STL findings. There was also a challenge, a failure that was said to be the limited enforcement power. The STL lacked its own enforcement mechanism, relying on member states to apprehend and deliver the accused. The individuals indicted were associated with the Hezbollah, a powerful political and military organization in Lebanon, making their arrest very, very difficult. Number three was another failure was the lengthy legal process. The legal process was protracted with significant delays in the trial. This prolonged the timeline and raised concerns about the efficacies and effectiveness of the tribunal. The trials were conducted in absentia, and accused individuals remained at large and are affecting the perceived impact of the tribunal. There was also a public skepticism. There has been and there was a public skepticism about the STL proceedings, with some segments of the Lebanese population questioning its impartiality and effectiveness. This skepticism was linked to a broader political division in the country. Having had said before and still saying that Hezbollah was a strong political armed group that had its own following and numbers. The STL had been also unable to apprehend all the suspects indicted in the Hariri's assassination because of what I also said, that this group was an armed military group that could move across Middle East wherever, whenever. The STL again on the sixth failure had been criticized for its high cost, which has been borne on the Lebanese government and the United Nations. So all in all, in summary, I could say, looking at this, you could see there were a little successes that were listed against what is called the failures. But these few successes that are listed are tremendous and very tremendous in so many things, and in the success and in the peace of Lebanon and other Middle East terrorism acts. that has been controlled, especially by this. However, it was also felt that this tribunal, as one of the disadvantages, it was also felt that it only concerned itself with the Harids case. And the larger majority thought that there were other terrorism around the area, and that which could also have been brought to book, but were not. So they felt that only Harid's case was highlighted much more than the rest, than what they felt could have been done so far. So in conclusion, a combination of the legal procedures, political and financial and security challenges that have contributed to the delays and what is called the unsuccessfulness doesn't really compare to the few successes, such as the delivery of justice, deterrence, establishment of legal precedents, promoting accountability, enhancement of international corporations that we've all spoken about. Thank you very much, and I yield the time to my next speaker.
So this is the final section of our presentation, which basically revolves around the major contributions of the tribunal to the international criminal law. And the first one is that this particular tribunal, being the Special Tribunal for Lebanon, is actually the first tribunal of its kind when it comes to dealing with terrorism as a distinct crime, which is described by the United Nations Security Council as a threat to international peace and security. And to bolster this particular contribution, I will make reference to the very popular case that you've heard us mentioning over and over again. And this is the prosecutor versus Hassan Habib Mahi and Hussein Hassan Onaisi. And this is the Harir case. And this particular case, just a brief background, is it originates from an explosion that led to the assassination of the former Lebanese prime minister, being Mr. Rafik Harir and 21 others, and injuring at least another 226 people. And following this attack, we now see the request by the Lebanese government to now the United Nations Security Council in regards to the formation of a tribunal to investigate and to give a verdict on this particular case. And one thing that stood out for me, or that stood out for our group, in relation to now how the Special Tribunal for Lebanon is the first tribunal of its kind to deal with terrorism, is the fact that the judges took note of the fact that terrorism is quite a heinous crime. And as is apparent from the facts of the case, terrorism is basically a crime that disregards human life, and it is a brazen disrespect for the rights of others. And they seemed to have agreed with what the United Nations Security Council was saying in regards to how terrorism is a threat to international peace and security. And the judges in their judgment were saying that terrorism is a threat to the peace, safety, and harmony of the community, as it destabilizes the country and its social and governmental institutions. And this is a case that I believe each and everyone should go and read. I believe we will post it as a group in the classroom. And the other contribution is that for the first time in the history of international courts, an independent defense office was established. And this particular defense office had the same status, or rather had a status that was equal to that of the office of the prosecutor. And the mandate and the role of this particular defense office was to basically protect the rights of the accused or suspect at all stages to ensure that they get a fair trial. I believe generally we know that, accused, they have this, people have this informed opinion about them, in that, maybe they should be banned or they should be killed so as to be able to equate to what they've done. But we are seeing that as a result of the establishment of this particular defense office, we are seeing that the rights of the accused, the rights of the suspect when it comes to cases are being protected. And this ensures that this particular people get a fair trial. And this can be found under Article 13 of the Statute of the Special Tribunal for Lebanon. Another contribution that this tribunal has had to ICL is the fact that this is the first international criminal jurisdiction to exercise jurisdiction solely over domestic crimes. And we are seeing that the Special Tribunal for Lebanon is an international tribunal that is exercising jurisdiction solely on the basis of crimes drawn from a domestic source. And in this case, it's terrorism. And the provisions of the Lebanese Penal Code relating to the prosecution and punishment of acts of terrorism, when it comes to the relevant articles relating to crimes and offenses against life, we're seeing that being provided for in the Lebanese Penal Code. And I'll just bring this home in a way, in that sometimes when it comes to certain cases or certain issues, you find that we tend to run to international statutes, we tend to run to international instruments, whereas our domestic laws are actually sufficient, or this particular domestic laws are able to provide some sort of guidance when it comes to the prosecution, when it comes to the punishment of certain offenses. And we're seeing that through this particular tribunal, it gave some sort of prominency to prosecution and punishment of domestic crimes in reference to now the provisions of domestic laws. And in this case, we have the Lebanese Penal Code. And then the other contribution that the Special Tribunal for Lebanon has had to the ICL is one that I find to be very interesting, in that it has advanced the jurisprudence on the issue of corporate criminal liability when it comes to international criminal law. So a very brief yet interesting background is we are seeing the Nuremberg Charter here, and the Nuremberg Charter actually went ahead to introduce corporate criminal liability into international law. And we're seeing the Chief Prosecutor Justice giving a promise and saying that, any legal person who actually commits crimes that have been prescribed by international law shall actually be prosecuted and punished in accordance to international criminal law. However, during this particular period of time, when the Chief Prosecutor Justice was giving this particular promise, a corporation was actually never prosecuted per se, because the sitting judges at that particular time did not seem to have, the will to dwell on the establishment of the elements of crime that needed to be satisfied in order to impute criminal liability on a corporate body. And then later we are seeing now a similar promise being made in reference now to the preparatory works of the Rome Statute, and it was more or less the same thing. But then due to time constraints of this particular preparatory works of the Rome Statute, it resulted in literally no inclusion of legal entities as subjects to ICC and international criminal law. Thus, it only remained a notion, it only remained something very fictional that is yet to be developed and yet to be exercised in the domestic practices. And then now here is where now the Special Tribunal for Lebanon comes in. And we are seeing the corporate criminal liability being developed domestically. And as time continues to change, we are seeing now the STL taking up a case, which is now the prosecutor versus New Tivisal and Al Kayat decision on interlocutory appeal concerning personal jurisdiction in contempt proceedings. And we are seeing now the Special Tribunal for Lebanon taking up this particular case that concerns corporate criminal liability and actually going ahead to prosecute corporate body. And this case was actually a landmark case, because we are seeing a corporation being brought before an international tribunal. And then we are seeing that particular, we're seeing the aspect of international corporate criminal liability at play. So clearly it was very, very important for the Special Tribunal for Lebanon to take up this particular case, because it contributed to ICL in that now we are seeing that just by the mere fact of the STL taking up this case, it now brought some sort of bravery in that now the scope of jurisdiction was widened to include legal entities, and therefore it served as some sort of encouragement to the ICC and other tribunals lacking such power. And we will conclude our presentation by stating two things. The STL has its successes as well as its failures. And that is okay, because when it comes to such like new tribunals, now it was being formed at that particular time, it was obviously bound to experience failures because it was just being established. And as a result of the same, we have two recommendations. The first one is that there is a need for a more systematic approach. And this means that when it comes to now the issue of policy discussion in Lebanon, there's a need for the policy makers to understand the issues and the implications that are being faced, in the different, like now in Lebanon, for example. And from this point of view, there are many lessons to be learned, because here now we are seeing the interface between politics and the law. And the STL provides a perfect example on how best we can ensure that this systemic approach is actually there. And there's also the need for a strategic communications approach, because some of the problems that the STL were facing were due to difficulties in communications. And the STL itself has limitations in its communications capabilities, because it cannot interfere in or contribute to political or international policy discussions. So it is important for the communications and policy discussions to be strengthened, in that now, before an indictment, like at the time before the indictment, at the time of an indictment, and during the trials, like the communication approach is consistent all throughout, and there is no break at any one point. At this point, I would like to thank each and every person for listening, and would like to pass it over back to you, sir, and to open it up for questions, comments, and feedback.
Okay, thank you for that, team. I think you all deserve a hand. It's a very good presentation. I'm now going to open it up to questions. Are there any questions from anyone? As you're waiting for questions, I have mine. One is that there's been a criticism against this particular tribunal on two grounds. One, they say that it's not a real tribunal for the reason that it's only investigating one particular incident. Secondly, for the reason that the offenses relate to the Lebanese penal code, like we've seen. And then thirdly, because it's actually getting involved with offenses that are not really international crimes, core international crimes. So if you're dealing with terrorism, those are not international crimes, really. And so some people say that it is not a real international tribunal. So I'd like to hear your views about that. Secondly, the issue of trial in absentia, what led to that? And was it a good or a bad development in international law? Yeah, I think let's leave it at that. So, and then the issue of one event leading to the establishment of a tribunal. So just the assassination of one individual leading to the establishment of a whole tribunal with all these things, all these officials, all these people. So the question is was it really worth it, worth the effort, worth the expenses, just to investigate one particular event? Maybe there. Tim?
Thank you very much, sir, for those questions. I will attempt to answer a few, and then I will also give my colleagues an opportunity to respond to the questions that you've posed to us. I will begin with your first question in regards to whether the special tribunal for Lebanon is actually a real tribunal. And I think in our reading we also came across this, and as a result of what we read, we believe that this particular tribunal is a real international tribunal. And I don't the fact that just because this particular tribunal was created with the intention of investigating and prosecuting those responsible for the assassination of Rafiq Hariri, that in itself takes away from the fact that this particular tribunal is not a real tribunal. And maybe just to further into that particular answer, there was an article that we came across, and there was a recommendation to this, in that now the jurisdiction and the scope of the type of cases that this particular tribunal can hear needs to be expanded. That way now it is able to hear, matters, other matters. But this is still a very, I don't know if sketchy is the right word, like it's still a discussion that is being built upon. But maybe just to answer your question directly, from our findings, we found that this is a real tribunal because it was investigating a case or an assassination that was actually real, and it's something that happened. And it wasn't like a hypothetical case or something along those lines. And then now, in response to your question about trial in absentia, we actually found this to be quite a unique thing, because we are seeing a scenario whereby this particular tribunal is given the mandate or is given the power to actually proceed with, proceedings in the case where the accused is not physically present. And just at the top of my head, this poses two particular scenarios. We have an advantage and a disadvantage. And the advantage is that sometimes you will find accused who are not cooperative, and you find that the victim in this particular case ends up, the mental turmoil is quite, enormous, because these crimes are not petty crimes, these are not small crimes, these are big crimes that have a mental impact on this particular victim. So the advantage to this is that the victim, gets access to their justice, because this trial in absentia doesn't just happen. There are certain conditions, there are certain measures that must be put in place so as to ensure that this particular trial in absentia is happening in the right way. And the disadvantage obviously would be that the accused will come in later on and say that I was not accorded a fair hearing, I was not accorded a right to be heard. But then if someone is not cooperative and we have a victim on the other hand, then which particular route will we go to, and which particular side will we end up going for? Because you have a victim on one hand who is hurting, and then you have an accused on the other hand who is claiming that they were not accorded a fair trial. So when we were reading, we noticed that it has its pros and its cons. But then in the face of humanity, I think it's correct for us to say that this is actually a good thing, because the issue of expedition when it comes to disposal of cases, the issue of ensuring that the victims are getting access to justice without a prolonged delay, I think that's an aspect that cuts across. So I'll just allow my colleagues to maybe say something in regards to the question.
Yes. Can I come in?
You can have
Yes.
Washington, Solomon.
Yes. I'd like to support what my colleague has said. Yes, the Tribunal for Lebanon was a real tribunal. It was established by the United Nations Council in 2007 to investigate the prosecution, and not only its establishment made it a real tribunal, but the STL was established, but its establishment by the United Council, United Security Council in 2007, which also United Security Council resolution in 1757, which was adopted anonymously by the 15 members of council on 30th 2007. These members lively voted for it, putting it into that perspective as it is as a real tribunal. The statutes and the rules of the procedures could show you that it is a real tribunal. The judges and the staff, the STL was composed by the judges and staff from all over the world, representing different legal systems and backgrounds. This ensured that the tribunal was going to work independent and impartially. This also was an evidence. I'm just bringing evidence that can direct you to maybe satisfy you that it was a real tribunal. Investigations and prosecution that happened, the STLs conducted a comprehensive investigation into a real assassination and other related crimes around it. This investigation involved collecting evidence and interviewing witnesses as per the basics and standards of a tribunal. The appeal process also was an indicator that the STL judgments were subject to appeals. You know, the appeal chambers and the STL reviewed the judgment and untimely upheld the convictions of one individual which was found. So basically, I'd just support what my sister has said. And on what you've asked, or whether I don't know if I got you right, but maybe you'll correct me if I didn't get you right. I've heard you saying that whether the special tribunal was for Lebanon was worth it because of Rafiq Hariri only. I don't know if that is what you asked. If so, I'd like to answer it with these arguments in favor of it. That the justice for the victims, the STL delivered a measure of justice for the victims of the Hariri assassination and other related crimes. The families of the victims received some form of closure and accountability, which was valuable in its own right and could have never been received if Lebanese system tried it on their own with their legal system mechanisms, because of the people who are involved, the Hezbollah, who are the power and the military prowess. Deterrence. The STL prosecution and judgment sent a strong message of deterrence against the future acts of terrorism and political violence in Lebanon. This could politically help to prevent similar tragedies from occurring in the future. Now, you asked that acts of terrorism are not what is called international crimes. However, you realize from these regions, these small acts of terrorism always developed into international crimes. Let me bring you up to speed. It is there. Look at the Gaza Strip. It is just a small group of terrorists per se. Let me call them that, though some of us may not agree with that word. That decided to bomb few innocent people in Israel, and then all of a sudden it has grown into international crime scene. So getting a body to control this down before it escalates up there international crime is a thumbs up for me. That the international crime is doing much more in regulating it down there before it grows up. That is how I could argue it. Maybe someone else could think of something different. Then also look at the strengthening of the rule of law. In this region of the Middle East, there was no, okay, let me say there is a rule of law, but there is no strengthening of this rule of law. The STL helped to promote the rule of law in Lebanon and the wider region of the Middle East. This was important for fostering a culture of accountability and respect for human rights. Accountability and respect for human rights. I could also say that, this Middle East had not been having cooperations with the international community. Now, this was a door, and it was one of the greatest door for international community to put their one leg in resolving some of these international crime issues. The STL operations required corporations from numerous countries and international organizations. These corporations always demonstrated a collective commitment to combating terrorism and upholding international law. If we can convince Lebanon and all other countries that are surrounding it to combat terrorism, then it will not grow into international crime. Majorly, that is what I could respond to your question, if that was your question. You also asked, before I yielded the floor, you also asked if the decisions to hold trials in absentia at special tribunals for Lebanon was it necessary, or did it hold water? Something in that line, unless I forgotten. But to me, how could I have responded to such if someone asked me? I could say that there were several factors that were laid down. Failure to arrest the accused. You know, these accused were not your normal accused. These were Hezbollah militant groups that the international community didn't have even their own military capacity to get hold of them, leave alone Lebanon on its own. So it was not by design and want that this happened in the absentia. And if they waited for them, for these trials to continue, maybe these trials could have never happened. And it is the same reasons why there was a failure, which I read before, that this prolonged time of this trial brought about high cost, which was detested. Two, it was also seen as injustice to some of the people, because they felt that this justice was delayed and therefore denied. So it was also to safeguarding the rights of the victims. You know, if this closure did not come out, we waited for these victims to be arrested. The STL recognized the rights of the victims and their families to a fair and expeditious trial. Holding the trials in absentia allowed the courts to ensure that the victims' voices were heard and that they received some form of justice, even though the accused were not physically present, but they knew they received this form of justice. The precedents in another point is that the precedents in the international law.
Recording stop. Recording in progress.
The STL relied on precedents established by the other international criminal tribunals, such as international criminal tribunals for the former Yugoslavia, which had successfully conducted trials in absentia. You know, so it was not just one off. These precedents demonstrated that such trials could be fair, legitimate, and while also ensuring that justice was not delayed indefinitely. You know, so they looked at the international criminal tribunals for the former Yugoslavia, and I think they sought to borrow and see that as long as this justice was not delayed indefinitely, it could still be delivered in a fair way. The legal framework, as my last point, is that the STL statute and rule of procedure and evidence specifically allowed for trials in absentia under certain conditions. These conditions included ensuring that all reasonable attempts had been made to arrest the accused, and that they were aware of the charges and proceedings against them. However, you know what kind of accused people we are talking about, the militia of the Hezbollah. Thank you very much.
I would also want to come in and maybe briefly add on to what my colleague has said. And we had that discussion admittedly in the group, and we tried to build consensus on our position on the same issue, but it's good to agree from the jump that the Special Tribunal for Lebanon was not your typical international criminal tribunal in the same frame of what we had in Yugoslavia and what we had in Rwanda, because in Rwanda, if we do comparative reading, we admit that there was multitude of crimes ranging from rape, incapacitation of people through cutting off of limbs and all that, and the same case applied in Yugoslavia. But the trigger in Lebanon was just the killing of the prime minister. But now what would necessitate international intervention, and what would make the domestic mechanisms not competent enough to deal with what happened. From 1943, when Lebanon assumed self-independence, government has been split along sectarian religious interest. The president is always a Maronite Christian. The PM is a Sunni Muslim, and the Speaker of the National Assembly is a Shia Muslim. So after the assassination of the PM, who is a Sunni Muslim, there was suspicion that the president had a hand with the help of some functionaries from Hezbollah, a terrorist group. In that scenario, trying or indicting the president would make the Christians rise up against Sunni Muslim. The speaker, who is a Shia Muslim, also delayed ratifying the decision to establish a tribunal because of political differences. So this is what informed international intervention. You also alluded to the cost that was involved and the convictions that were secured. As at the time we were compiling the report, there was still discussion on whether to wound up the special tribunal, and a little over $1 billion US had been spent with a conviction secured. We'll leave it to the people who will do the post-mortem after the tribunal is concluded to form an opinion whether there is cost-benefit analysis for what was spent and what the tribunal meant to achieve. But from our standpoint and from the consensus in the group discussion is that there was no way out. The international community had to come in and form the tribunal, because you also realize the circumstances surrounding the year 2005 when the assassination happened. It was a little soon after the 9/11 in 2001, and municipal intervention to arraign and punish people who are involved in terrorism had also received a lot of backlash from the international community and human rights groups when the US tried to detain people in Guantanamo Bay under municipal law. So it was only fair if the international community was to come in and help Lebanon deal with the terrorist attack, which there was suspicion that Hezbollah was involved. And Hezbollah, in terms of their doctrine, they are aligned to Al-Qaeda. Then it was only fair that the international community then help Lebanon form a tribunal, because even the mightiest nation on earth, the United States, had tried to apply municipal law to deal with the issues of terrorism against their own international interest, and they were failing. And actually, at that point in time, that was also forming a big discussion in the US, leading up to the election on whether the government of the then president was going against contravening international convention on human rights in Guantanamo Bay. So it was not advisable then, given the local political realities in Lebanon, to try and apply municipal law to apprehend people who are involved. It was not tenable at that point in time. So that's our take regarding that question. Thank you.
Thanks, Solomon, and Zedekiah and the entire team. That was good. I am not yet persuaded, because there's so many issues. I mean, how do you spend $1 billion US just to get 3 convictions? It does not make sense to me. But anyway, I will not go into that. Like you said, that will be a postmortem to be done later on. But I'll ask any other person with any other question. And I'm seeing Alfred had a question. Alfred, did you want to say something?
No, Mwalimu.
No, I'm saying you wrote something. You're basically citing domestic incompetence to justify international intervention.
Yes, I was actually reacting to Washington's explanation, and I think the same has been captured by Solomon Kinubia in his response. So it was just an observation.
Okay, good. Any other person in relation to this interesting tribunal called STL, Special Tribunal for Lebanon. Yes, Onyeke?
A quick one. Now, thank you very much. Just a curious, the fact that the Lebanese government is the one that requested the international, the UN to set up the tribunal, and they had an agreement. From a perspective of someone looking from the outside, does it then it would look as if the Lebanese government already knew they wanted to be prosecuted for this, and that is why they asked the International Court to form the tribunal. That is one. And two, the fact that even after convicting this one person and the three of them and the others in absentia now, and not being able to have jurisdiction over international humanitarian law because it was only one act on the acts of terrorism that was the mandate, but the international humanitarian law and genocide were not part of its mandate. Maureen, and this one you can explain. Was it really, does it deserve, even if there was a presence of international judges, and does it deserve to be called a tribunal?
Recording in progress.
So, sorry, Onyeka, you said at the end, I think I lost you. At the end, you're saying, does it deserve
in the end,
an international tribunal?
Yeah, so in the end, we justify calling it an international tribunal just because we hired international judges and we had an agreement with the UN Security Council.
Yeah. That's actually that's a point I was trying to raise. Is this really an international tribunal? Do we then call this an international tribunal just because you have foreign judges? But remember, these foreign judges are applying Lebanese law, and like Onyeka has aptly put it, they are dealing with a situation of terrorism. They're not dealing with international crimes. And well, Onyeka, not just because they have foreign judges, but also because the Security Council also determined that the tribunal should be established. And so this is where now you see the politics of international law, criminal law. So the Lebanese government, you get $1 billion shillings being spent on these few cases, which are still going on, I think. And on the other hand, you had the genocide in Rwanda, and the Security Council had to be persuaded to establish the ICTR. And in fact, the ICTR was established because the ICTY had been earlier established. And so it was just to make it look like we're balancing the situation. So let's have ICTY, and now let's also have ICTR. And ICTR makes sense. But this STL, personally, I don't think it makes a lot of sense to have it there. But it is what it is. We've spent a lot of money on it, $1 billion, but I'm not seeing the sense of it all. But also, a question I wanted to, and unless the other people want, I think it's partly what they had said earlier, that some of them think that it's still there, but I'm still not persuaded. But the other question I wanted to ask the team, what definition? Remember you said you're dealing with terrorism. So how do they define terrorism? Remember, terrorism is a very, very difficult thing to define. One man's terrorist is another person's freedom fighter. How did they define terrorism for purposes of the tribunal? And also, I'm not persuaded about the issue of trials in absentia. They don't make sense at all. I mean, even in the ICC, they are powerful people, al-Bashir, was a president, but he was never tried in absentia, as powerful as he was, because there are basic fundamental principles of criminal law, of international criminal law, and one of them is that you cannot be tried in absentia. So this is a very strange, to me, I find it also very strange that you have people being tried in absentia because they are powerful and because they are terrorists and because they have a lot of money. But even the ICC does not do that. It's yeah. But anyway, let's leave it there. Any other thoughts? Thanks for those thoughts. Any other additional thoughts before we close? From any other person? Yes, Chelsea?
Mine is more of a reaction, and I think we also found it to be a very interesting tribunal, but maybe in just like 2 minutes, you've asked a question in regards to the definition of terrorism and what the statute for the Special Tribunal for Lebanon has to say about it is not very far off from what the popular case, the prosecutor versus the people that were the Merhi and Onaisi, the Rafiq Hariri case. And it's not so, so different, because they were saying that terrorism in this particular context is a crime that is very heinous. And it is a crime that has total disregard of human life, as well as it doesn't respect, the rights of others. But then on the other hand, another helm, it also says that, terrorism is that crime that has the potential to disturb international peace and security. And this is sort of in line with what the UNSC was trying to say. So here we're seeing it's like now 3 people coming together to have like some sort of similar definition when it comes to what terrorism is. But then also on the same breath, they were also saying something along the lines of use of violence, fear, and intimidation to achieve, political, ideological objectives. And even when we're going back to the background of this particular case, we're seeing the impact of the assassination of the former Lebanese Prime Minister Rafiq, and we're seeing the revolution of that particular movement, in that now they were triggered as a result of the assassination of this particular person. But just to respond to your question, that is what, it's like a summary of what the statute says, and that is found in that particular case. And this is along the lines of systematic use of violence, fear, intimidation, with the aim of achieving a political, ideological objective. And it involves, targeting of civilians to create some sort of fear and panic. And I feel like that was actually achieved as a result of the assassination of the former Lebanese Prime Minister, Rafiq Hariri. Back to you, sir.
Great, good. Thank you, Chelsea, for that. Very incisive. I think we are done for today. And I think we're almost done with all the tribunals. There's only one more tribunal called the Extraordinary Chambers for Cambodia. And obviously, because of time, we are not able to look at it today, but we're going to look at it next week. And then from there, we'll see how it goes. But thank you very much, everyone, for your participation. Yes, Muturi Cosmas, you have your hand up.
Yes, Mwalimu, you have seen that we are remaining with one group. That is the one dealing with the Extraordinary Chambers for Cambodia. Mwalimu would also request that, the group 5 that did some work that did not please you and the class, that it be given a second rebuttal on that is on Wednesday next week. To be very brief, because Mwalimu, we are running, we must satisfy the class, and also the group must feel satisfied that they have done justice to themselves and the class.
I'm not too sure, because I've already given you enough time. You were not the first group. If you're the first group, it would have made a lot of sense. But you were one of the later groups after I'd already made a lot of comments on the previous classes. So I'm not very inclined in that particular way. And also we don't have we don't have a lot of time on we need to do other things. Also, something else, the class, the people, the group leaders in your groups, please send me your presentations. Okay, please send me your presentations. The Cambodia team, you ought to have been ready even to present today, but nonetheless, you're very lucky Lebanon were able to take your place. But now next week, Cambodia, it's your turn, and then we'll close. I think next week should be the last class before we close for Christmas. Okay, I think let's leave it there and have a the tribunal seems to have tried the backslash after that. Okay, yes, the car before we close.
Thank you, Mwalimu. Now that the faculty or the universities still has a challenge with the storage issue, would it be better if we send them to your email direct and you provide us with
actually,
your email
that's
address?
the only. No, I understand that. That's the only way now of operating. It's not a very ideal situation for me, but let's use the circumstances that we have. So everybody, even the previous people who had presented, the previous groups, sorry, kindly send your slides to me by email, and then we'll finish. So now next week we'll just remain with one particular group. Okay, good. Thanks. Unless there's any, I think we'll leave it there. Have a very, very nice evening and see you next week. Bye-bye.
Thank you and good evening, sir.
You too.